Hello,
Hello,
hello.
everyone.
Hello, hi. Sorry, I was having some tech issues, but I'm good to go.
Everyone's
How's everybody doing this evening?
Great.
great.
It's really, yeah, good day. It's really pretty outside too.
It was
Yeah, it's
a
too
real
bad I
summer
spent the whole
day.
day indoors, but
Yeah,
it
exactly.
sounded nice in theory.
Yeah, it was so gloomy yesterday, but today it's actually really bright out. I have my windows, like my curtains all open and
Yeah.
been a good day.
I like it when it's cool at night, like it is these days, and just helps you sleep all cuddled up in the covers and makes it cozier.
Yeah, I haven't left the desk all day today, so hopefully after this I can go sniff some fresh air outside. See the
Touch
color,
some
see the
grass or
sky,
something.
some grass, touch some grass. No, it's been a long
Frolic in
day
a
today.
field.
Yeah, it's okay though. It's okay. So we have an exciting topic for today. I'm really excited to dive into it, and we have the best of the best joining us today as a guest speaker, Jonathan Paynter. He knows everything, and I,
Me?
I know I know him exactly. He knows everything when it comes to anything family professional related. So I'm really excited that he's here to join us today and to speak with us today.
Yeah, it's always fun doing these events and nice to have my first event with Jodeen and Joseph. Um, I've met you both before, but we've never done one of these events before, so that's very exciting.
And you're lucky. Shanza's spoken highly of you on the last one you did with her. So there's no secrets
Shanza's
there.
she's an expert. She's an old hand at this now.
No, it was so great to have you last week, Jonathan. And even this week, I feel like I am one of the participants today. Like I can't wait to hear what you have to say because you do them and yeah, we're gonna hear everything from you today. So we're not letting you go until 6 at least.
No.
Sounds good.
No, I echo that. I had the pleasure of sitting in an event with Jonathan and clearly a very knowledgeable individual. So I'm also ready to learn.
That's what
I'm
today is.
glad.
That's what today is all about, right? It's about everyone putting their heads together, offering something unique and a different perspective, and from learning from one another. And hopefully, when we all learn from one another, that in turn allows our participants to learn as well. So it's a lot of knowledge gathering.
This just reminds me of our CP course with Jonathan.
For sure, for sure. Except now
Okay.
we're all working together and we're all putting our heads together to give a valuable presentation to our participants today. Who we have
Oh
a
yeah,
couple, we
because
have a
you
bunch.
you both did the course together, didn't you?
We did.
We did.
Yeah, and hopefully Jodeen will get in on that course at some point in the future. We'd love to have you.
Oh, yeah, for sure. I was just about to say I feel left out. So I'm looking forward to.
Do any of you have your mediation training as well?
Not yet. That was something that I've come across in terms of working with my clients and on other files with respects to mediation. And I've always wanted to do it. It's just, getting my foot on the ground and putting the pedal to the metal and actually following through on that.
Yeah, I mean, there's only so many courses you can take a year, right? And you just recently did your collaborative training, so uh, but I found and one thing that I like that your boss Russell Alexander says a lot is that learning collaborative and learning mediation actually makes you also a better litigator as well because you see cases from many different angles instead of just having one kind of laser focused on it. So even if you end up not practicing mediation, I think it's a really good training to take. But mediation itself is really good, and I would encourage you all to take it if you haven't already.
100%. Well, I love our chats, but it is 5 on the dot, so it is officially after hours. I will get us all started. Hello to our participants and welcome to Family Law Now After Hours. Before we dive into our today's topic, which is child inclusive mediation, just a few quick housekeeping items I want to make note of. So there is no chat function available, but feel free to send your Q&A using the Q&A feature at the bottom of your screen to submit any comments or questions. While we are here to provide some insights on separation, divorce, and family law, please remember that any information that we share today should not be considered as legal advice. Today, we are talking about child inclusive mediation, and we have our expert with us, Jonathan. He's joining us again after last week. Thank you, Jonathan. It's always good to have you here and hear all your wonderful insights. And also, towards the end, I will be sharing how you can get a free 20-minute consultation with one of our lawyers. So stick around until the end, and I shall share the code with everyone. I will now move on to our introductions. We have Jonathan. He is a registered social worker and psychotherapist who works in the family law system, completing parenting plan assessments, voice of the child reports, family mediation, and collaborative family law in private practice. He also provides psychotherapy such as cognitive behavioral therapy, family therapy, and couples counseling for children and adults. Jonathan is on the board of directors of the Ontario Association for Family Mediation, holding the executive position as treasurer of the board, and is on the board of the Collaborative Practice Durham region. We have Joe joining us back. Joseph is a compassionate family lawyer driven by a deep desire to support families through challenging times. With a background in commerce, he brings strong negotiation and critical thinking skills to his legal practice. His passion for family law was further honed through legal writing, research, and hands-on experience in the family and children's law placement at Queen's University. During his articling period, he gained confidence in handling a wide range of family law matters. He emphasizes active listening, clear communication, and empathy, fostering a comfortable environment for clients to discuss personal matters. He is certified as a collaborative professional. He offers an alternative dispute resolution approach to avoid court. Outside of work, Joe is a dedicated sports fan and enjoys playing hockey and watching movies. And today we also have Jodeen joining us today. Jodeen is an articling student at Russell Alexander, and she is the newest member of our team. Despite her relatively short time with us, Jodeen has gained valuable experience across both collaborative and litigation files. Her legal journey began at Queen's University, where she honed her advocacy skills through roles at Neighborhood Legal Services Legal Clinic and the Family and Children Services of Frontenac, Lennox, and Addington. These experiences helped her develop a keen ability to navigate complex legal issues with empathy and insight. Outside of work, Jodeen enjoys trying new and exciting activities, the most recent being ultimate frisbee. Okay, that's exciting, Jodeen. Lastly, there is me. I'm a family lawyer with a strong focus on compassionate and effective legal representation. My background in business management enhances my strategic approach to legal matters. I excel in negotiation, achieving favorable settlements through strategic dialogue and strong advocacy from my clients. I prioritize clear communication, ensuring that clients are informed and empowered throughout the legal process. Without further ado, I will now jump right into our topic. Jonathan, we're glad you're here to provide us some first-hand knowledge on how you conduct these sessions. So if you can get us started on what is child inclusive mediation, what does it entail, why is it so important to involve children in the process? Can you provide us with a bit of an introduction on what we're talking about today?
Sure. So a couple things I want to say first. The most important is that it is a child's legal right to have their voice heard in any court process or any legal process that involves them. So that's the basis of it. It comes from the UN Convention on the Rights of the Child. And we've done a lot of, well, not a lot, but we've done some research, and by we, I mean, people, not me, but other people have done research and looked into whether or not including children in legal processes like mediation is beneficial to them. And I will send a link for the show notes to a study that is quoted on the Justice Canada's website. The study was done in part by Dr. Rachel Birnbaum, who's a very famous researcher in family law. And she found, this is her conclusion in her report, it says, while the debate continues in the social science literature regarding whether or not children's voices should be heard in the process, the research literature to date provides a resounding clarion call. Children and their parents have better relationships. There is less parental conflict between the parents and when the children are part of the process. So there is both a legal basis for why we should do this and a research basis that shows that it is beneficial for kids to get involved in major decisions that impact their lives. And generally, when we're talking about child inclusive mediation, we're talking about older kids because they have to get to a certain developmental ability before they can, understand the legal process, understand concepts like consent, and know that what they say in a voice of the child or child inclusive mediation process, they need to know what the consequences of participating in that might be. So generally, you want to do this with a bit older kids. So you wouldn't do this with a 3-year-old or a 4-year-old. I would probably go up to 8 would be the very, very lowest that I would usually see a kid, and those would be the more mature kids. But usually by the time the kids are 10 or 11, I'm recommending routinely with parents who are coming in for mediation that we should get the children's views and preferences and figure out what they would prefer, because that's an important piece to bring into the process. But one of the things that can prevent, and one of the reasons why I think it can limit conflict between parents, is because children will often say to their parents what they think their parents want to hear. So they'll tell parent A, I want to live mostly with you. And then they'll go to parent B and say, well, I want to mostly live with you. And that might be true. Like they might in the moment really believe that, but both parents are hearing very different things from the child. And that alone can create conflict, because then parent A says, well, I know the children want to live with me. And parent B says, no, you're wrong. Kids want to live with me. And that can create a lot of conflict. So when you actually have the views and preferences of the child, it can really help reduce that conflict, because now you're actually figuring out what the child wants, independent of the opinions of their parents and influence of their parents. Hopefully, anyways.
No, those are some great points, Jonathan. And, I have clients where, what you said, the children, they tell different things to both parents. And I have clients where both parents have completely different views and understanding of what the child wants. And having this avenue, this third person, this expert, like speak and hear what the children want can really provide direction, especially when there is just no agreement and there's not a lot of communication between the parents. So having like this third person, a mediator come in can provide much needed direction in a case, which could be at a standstill because, there's just no agreement anywhere.
The other flip side to that, Shanza, is I have met with parents and we've come up with brilliant, textbook beautifully parenting schedules. And when the parents go and show the children that, they're like, hell no, I'm not doing that. What are you talking about? Nobody asked me what I wanted. And so you have to like throw all the work in the garbage and start from scratch. So, particularly if the kids are teenagers, I would recommend that, in every case that comes to family mediation, you should consider getting the views and preferences of the child included in that process.
100%. I have this client and she has a teenager and she's like, I'm not even gonna decide anything here. She's gonna decide everything. And when they're older, they have a voice. So, it's
Yeah.
only fair that we give them the avenue to communicate their voice and what they want.
Yeah.
Yep, thank you. So I'll just take a minute now to kind of expand on some of the advantages and challenges, because we kind of have this conversation going right now about the advantages of, child inclusive mediation. Not only does it allow the children's voice to be heard with the help of this direct communication, it also allows for parents to be more informed on what the child really wants. Like you said, Jonathan, it means less conflict, more child-focused conversations, better long-term outcomes with more sustainable parenting arrangements that are, mindful of what everyone wants. I think it allows for empowerment for the children too. It gives them a sense of involvement and control in the process, which can definitely reduce feelings of helplessness for the children. But on the other end of the scale, there's, I think, obviously some challenges associated with this process too. So it might not always be best suited for everyone. And we want to talk about situations where child inclusive mediation is a good idea, but we also want to talk about situations where it's not. And I think some of the examples could be very high conflict cases, particularly those where there may be a lot of domestic violence or emotional manipulation, where children can see this conflict, and it's not well hidden from them. And in those cases, they may feel pressured or caught in the middle. But I'm kind of hoping, Jonathan, you can kind of, as you know, you do these sessions, so you can maybe tell me like how you kind of address these things. But there definitely has to be some willingness between the parents to work out a solution and to really hear what that child wants to say. I think it's a sad reality, but there are parents who try to coach the children. This is anything but child-focused behavior. And I think there are cases where we also see parental resistance. So if parents aren't willing to respect the child views or engage in meaningful compromise, child inclusive mediation might not provide as much assistance as we would like it to. So yeah, I think, Jonathan, I would like to hear from you a little bit more on that. And I think if you can also talk a bit more about our next topic, which is more ethical and legal considerations when involving children in mediation, because it kind of also hits on, you know, the parents' obligation to kind of listen to the children. How can these considerations impact the decisions made by mediators, parents, and legal professionals regarding the child's participation?
Yeah, you made some really great points there, Shanza, and I'll just add to them a little bit. But let's kind of back it up a little bit and take kind of like a bird's or even satellite eye view of this. The first ethical consideration might be depending on your profession. So different professions have different ethical obligations to their client, and they can differ significantly depending on the kind of professional that you are, right? Like a lawyer, for example, doesn't have the same ethical responsibilities as a social worker. And a social worker doesn't have all the same ethical responsibilities as a lawyer. So you want to make sure that if you are a professional doing this, you want to make sure you do your due diligence and find out what your college or your governing body says about, you know, how to go about doing this work ethically. So for me, I'm a registered social worker and an accredited family mediator. So I would be bound by their standards of practice and ethics. So one of the most important ethical obligations for my profession is the do no harm principle. So number one question is including the children going to cause harm to this family or to those individual kids or to the process? And you want to make sure that the answer to all three of those questions is no. You know, we want to make sure that we're not making anybody's lives worse by getting involved. And there are situations, and Shanza, you gave some good examples, like, for example, if there has been family violence, you know, there might be potential to do a lot of harm if you do your work in the wrong way. So you want to make sure you're very, very cautious about complex situations. The next consideration might be the age and stage of development of the child. You want to make sure that they can, for example, give consent. Are they psychologically and developmentally mature enough to understand what that means? What is consent? Do they have an idea of why you're getting involved? Do they understand the consequences of their participation in this process? So you want to make sure that that is built into your process, is making sure you're assessing the child's ability to consent and their age, stage, and development, and B, making sure they understand what they're giving consent to. So another consideration, ethical consideration might be like, would there be potential for the parents to negatively influence the children's answers? And might you be, you know, causing more problems in the family or in the court or in the mediation process by including the children? And there are some rare cases where that is an issue. I would say the vast majority of cases that I've had, it's appropriate to include the children, but there are always exceptions to that rule. And it's the obligation of the professional involving the parents to understand what those ethical considerations are and how to mitigate them if they come up. So what Shanza and Jodeen and Joe, you three are lawyers, from a legal point of view, what would you say some of the legal considerations might be of including children in the process?
I can speak to that a little bit.
Yeah.
So obviously we've mentioned that that the inclusion of children is bound on certain characteristics, and that in law they do have a right to be heard, whether that be through the voice of the child report, if it's like a section 112 assessment. There's various ways in which children's voices are heard. But I think if we bring it back to the reason why children's voices are heard is that any parenting decisions, whether that be in respect to parenting time, whether that be in respect to decision-making responsibility, relocation, any one of those parenting factors, all revolves around whether or not decisions are made by parents or especially judges when they're issuing orders, whether they're in the best interest of the child. So going back to the mediation standpoint, as you know, as Jonathan mentioned regarding his college and, for example, the duty of no harm, that all goes back into what is in the best interest of the child. Is it in the best interest for the child, given their age, maturity level, etc., to be in this position, to be involved in this process? So in terms of the legal standpoint, there's nothing barring having a child be involved in the process, but as Jonathan did say, it has to be done in the correct way, and there has to be, which there normally are, at least in the litigation avenue, but especially if you choose to work outside of the court, either through mediation, collaborative family practice, or through collaborative family law, or even through arbitration, anything outside of the court system, that there are mechanisms in place that are ensuring that the best interests of the child are always being adhered to throughout the process.
Yeah, no, that's a really great point, and that's always everyone's most important consideration when they're either involving the children in the process or even just making decisions about the children, whether it's the judge or an arbitrator or a mediator or whatever. The best interest of the children is always the primary concern, for sure.
Yeah, 100%. And as lawyers, it's also our job to coach the clients, because sometimes they're so focused on the conflict, they want to litigate, they want to go to courts. But, as lawyers, we are in a position to recommend these avenues to our clients. And we know that, what the courts are going to look at. We know that, the most basic test, as Joe, you mentioned, is the best interest of the children. And at the end of the day, that should be the deciding factor. And, as lawyers, we're in a position where we have seen a lot of cases where, what path the judge would take, what's the right avenue here. And so, like, we should, more on the ethical and legal standpoint, we should make sure we're always guiding our clients in the right direction and kind of offering them all these different avenues that can potentially help them either settle the issue or, better hear what the children want to say, and they can better hear and enter into an arrangement that is best suited for the children. And, Jonathan, you were talking about different developmental needs for the children. And I think this is something where we also come in as lawyers to kind of like guide our clients on, what age and what development the children is at and how the conflict is going to impact them depending on what age group they're in. So, you mentioned children who are younger, they're 6 years old, they're 5 years old, there is very limited understanding of the complexities of, family conflicts. Their perspectives are often based on very immediate experiences. And so these children are more prone to confusion, fear. So they need stability coming from the parents. These children don't need to see a lot of conflict. And, coaching these children at that age is not going to benefit anyone. It's not going to benefit the parents. It's not going to benefit the children. So, the parents should definitely kind of avoid, involving children who are younger, within even the mediation process, because it's not going to provide a lot of direction. It's only when we're looking at children who are older, they're 9, 10, they're older, that's when they're kind of in a position where they can grasp family dynamics. Often these older children, they can feel divided loyalty between parents. They can have their own worries about changes in their lives and their routines. And that's where, Jonathan, you come in and mediators come in, because sometimes parents, they're too focused on the conflict. They don't always realize what the children want. And, this is where this process can be very, very helpful. Again, teenagers, they can have very strong opinions, but the impact on them on of a divorce and separation can be just as high. And so it's really important to have that communication with the children and give them that avenue to communicate their thoughts and their feelings. Yeah, so just wanted to kind of add those little points there. And talking more about children in different age groups and their developmental needs, another huge aspect here is communication. How do you want the children to communicate? How do you facilitate effective communication in this setting? And Jodeen, we would love to hear from you now. I would like you to speak on this. How can mediators, how can parents, how can everyone ensure that children feel heard and understood? And what are some communication techniques that can be employed here?
Thanks, Shanza. Yeah, for sure. When you think about communicating with children in the mediation process, I think it's important to use age-appropriate language. As we mentioned before, kids are at different developmental ages, so you don't want to use any complex language that will go over the child's head. And this is this is important through all aspects of the mediation process. So like when you're talking about consent, and you're explaining to the child not just children, but the parents as well, like this is effective communication for everyone. Don't use words that will, be too complex for the parties to understand, but for the children specifically, perhaps avoid legal jargon and ensure that you get affirmation from them, that they understand that what the process is about, what the consequences are, as Jonathan mentioned before, explaining about consent. So age-appropriate language is important. Then you also want to ensure that you are building like a trust kind of relationship. You don't want to you want to be able to facilitate the process. So you want the children to be able to trust that this is a safe space that they can engage and speak their mind. And so you want to ensure that you're building rapport, depending on how old the kid is. Like you're not going to talk to a teenager about Peppa Pig, like, so you don't want to roll that into your conversations.
Unless they really like it.
Unless they're really into it, or like My Little Pony. I know there's a group of young people that were really into that. So if that's what they're into and you've picked up on that, cool. So yeah, it's really just about getting to know them on a level where they're willing to feel safe in the space and express themselves. Ensure I think another important part of this communication aspect is maybe laying out like a roadmap, explaining what the process will look like, so that it doesn't come as a surprise to them, so they know what they're expecting, and what your role is, what their parents' roles are, and what is expected of them. Yeah, I think that there is something else, right? Always ensure that if you're ending off if throughout the conversation, you want to, intersperse it with interesting, fun topics like Peppa Pig or whatever. But at the end of it, you don't want to end on a serious note. there are a lot of serious topics that will need to be discussed. It's not just about creating a relaxing environment. There's a purpose to the mediation process, and you're going to have to ask those difficult questions, or broach those difficult conversations. However, it's important that they're not scarred by the process. So yeah, that's the
That
input
goes
I
back to
have.
the do no harm principle, right? You don't want
Right.
them to leave your office feeling super angry or upset or sad or whatever. So yeah, you're absolutely right, Jodeen. I like to weave in fun topics like what kind of video games do you like to play? What do you do on weekends? What's your favorite sports team? What's your favorite food? With the more serious conversation, tell me about your family and what's conflict look like between your parents? What are the parenting arrangements that you would like to see? And then, I always like to end my conversation with the child with something fun. So, if the kid's younger, I'll ask them, what's your favorite food or superhero? If they're older, I might ask them, what's your favorite music or sports team, something like that. So, yeah, you just want to make sure that child leaves your office feeling, good and not bad or upset, for sure. And, going back to what you said earlier too, Shanza, about understanding child development, if you're either someone who does this work or you're looking for someone who does this work, it's really, really important to find someone who understands child development, because older children, between the ages of like 12 and 16, they kind of look like adults, but their brains don't work like adult brains at all. Well, I wouldn't say at all, but there are very significant and important differences between the way an adult brain works and the way a younger child brain works. And one of the biggest differences is that an adult or an older child, like, someone who's 18, 19, they can have two different competing perspectives and understand them both in their head at the same time. Whereas younger children don't have that ability. That is something that kind of grows into your later teenage years. So they can only understand one perspective at a time. So sometimes that might mean that it's the last perspective they heard. So if they see you on a day where they've been with mom, they might share with you mom's perspective. If they've been, seeing you on a day that they've seen dad, they might share dad's perspective, but they won't really be able to understand two different perspectives at the same time. So is one of the important things to address that is to see them at least twice, once when they're brought in with their mom and once when they're brought in with their dad, to make sure that you're addressing that potential bias and you're kind of addressing those underlying developmental concerns that might mean that you're getting the wrong information from them, or you might misunderstand the information that's coming from them because you don't understand child development. So there is, if any of you is interested in pursuing this education, there is this is a shameless plug for the Ontario Association for Family Mediators, but on their website, and I can send it for the show notes, there is a training that they offer every year. It's probably going to be offered in the spring next year, that specifically trains mediators on how to do child inclusive mediation. So if any of the members of the public are looking for a mediator and they have older kids, make sure you find someone who has that experience and training, because that can be really valuable.
Thanks so much for that, Jodeen and Jonathan. So I am taking away from this, not only does communication differ when we're talking to children, it also differs depending on their age group. So, you kind of have to, depending on who you're talking to, you really want to, address how you are communicating with the children. And this kind of extends to something else that we want to talk about today, because communication and making children comfortable to talk to you, this relates to how to establish a safe environment for kids. Because if they have the safe environment, that's when they feel more comfortable to express their views, to talk to you and express their concerns in the mediation setting. What are some strategies that mediators and parents, including, can implement to provide that safe environment. And Joe, if I can get you to speak on this. Thank you.
Yeah, sure. So, first and foremost, uh, when establishing the safe environment for children, first and foremost, excuse me, children should feel comfortable, expressing their thoughts and concerns without any fear of reprisal or judgment. And being able to create a non-threatening environment encourages, as Jodeen mentioned, open communication, which is critical during emotionally charged situations like separation or separation, divorce, just going through any type of litigation, anything of that nature. And ensuring that the child knows their voice matters, but that they aren't responsible for the decisions that are as a result of their voice is essential to their emotional well-being. And that is something that should be supported by, both parents as well as the mediator or the family professional that may also be involved in the process. As Jonathan mentioned previously, um, Ontario family law does recognize that children can play a role in parenting decisions. However, similarly to what I spoke to above, the process should be structured so that children can share their views and their preferences without feeling pressured, and that parenting time or decision-making responsibility decisions or anything of that nature are determined, and then that are taken then into consideration what is in the best interest of the child and not of the parents. So the role of a mediator in their job and their responsibility is to balance hearing the child's voice without making them feel like they're choosing between parents. And it's really important to ensure that neither parent believes that the mediator is taking a bias to either parent when helping the parties come to a resolution regarding parenting. As we've discussed in depth today, involving a neutral third-party professional such as a child specialist, a child therapist, a counselor, or anyone of that nature ensures that children are heard in a supportive environment. These professionals are trained to help facilitate communication in a way that makes children feel safe and understood, rather than the alternative, feeling overwhelmed, feeling insecure, feeling like it is their fault, or any of that nature through the legal process and the decisions that arise out of such. It also allows the children to speak freely without feeling pressured by their parents, which is why it is so important to let these sessions occur. I'm sure Jonathan will speak to this, but oftentimes he has parents not in the room when he's speaking with the children one-on-one. And that's to feel that they're not feeling pressured in any way, that they're not making a decision or they're voicing their opinion that maybe the parent in the room with them might not agree with. So there's a lot of different strategies and mechanisms that family professionals put in place to ensure that this is not the case. Now, going back to the household, this is especially prominent if parents are still living separate and apart under the same roof. And that is to minimize parental conflict. So high parental conflict can obviously negatively affect children, and that makes it harder for them to open up and be vocal in their views and preferences. So it's essential that parents work to reduce visible conflict, especially during parenting time exchanges or even discussions about parenting. And all these discussions, especially if the parents are involved in the legal process, that none of these discussions occur in front of the child. That's extremely important. And I've seen in many cases, I'm sure Shanza can say the same, where judges have ridiculed parents for engaging in this type of behavior in front of the children. And being able to minimize parenting conflict sets the stage for children to express their views freely without feeling that, like, once again, they're caught in the middle of this crossfire. Going back to the legal considerations in that component, Ontario family law, and if parties are married, then it would also be encapsulated under Canadian family law, because there are the two components of such. If the parties are married, regardless if it's a federal legislation or if it's Ontario provincial legislation, such legislation is increasingly emphasizing the importance of the child's voice in family matters. especially where decisions on parenting time or decision-making responsibility are concerned. And the courts have actually recognized that children's opinions, when age appropriate, should inform the decisions made about their future, as Jonathan pointed out. However, once again, mechanisms must be put in place for outside of court, so either through mediation, arbitration, or through the collaborative practice to protect children from feeling pressured by either parent, which is why the use of family professionals is so important in this process. And that's oftentimes why, especially lawyers at our firm, we often highly recommend the inclusion of family professionals because they are so crucial to the process.
Yeah, and just to add to a couple things you said there, Joe, which were all excellent points. Creating a safe environment is like should be thought of on multiple tiers, right? Could be the physical environment. It's nice to have kid-friendly stuff in your office, like toys or coloring stuff, or something that is candy. I have a dish of candy over there, and kids like to come in and feel comfortable. So that's the physical environment. Physically, also, you want to make sure the parent can't hear you. So if your office door is very thin, you might want to ask the parent to wait outside in their car. And you also made a point about making kids comfortable so the parents don't have to be in the room. The parents can't be in the room, right? Because you're not going to get their honest opinion if the parents, or you may not know if you're getting the honest opinion if the parents are in the room. So you want to make sure that parents are separate and hidden and can't hear, and the children feel comfortable that their parent can't hear them. So that's an important piece. My colleague across the hall here has a noisemaker. So if there are people waiting in the waiting room, I'll turn it on. They can't hear what's going on in my office, which can help. It might also be emotionally important to help the child feel safe. And that's why, Jodeen was talking about, weaving in fun topics as well as more serious ones can help them feel kind of emotionally safe. And then, the other thing that's important is at the end of your conversation with the child, make sure you get their consent about what information you can pass on to the parents or the court and what information you cannot pass on. And they get to choose what information goes and doesn't go. And if you don't do that part of the process, you're not really getting their true consent. So what I'll do is I'll review some of the stuff that they said with them at the end and say, oh, you said this and this and this. Is it okay if I share that with your parents? Yeah, okay. And you said this and this and this. Is it okay if I share that with your parents? No? Okay, well, I'm not going to share that with your parents then. And that actually helps them with a feeling of safety as well, because now they feel like, well, this person's listening to me. I get to decide. I have a voice, and therefore they're more likely to give their opinions and express to you what they truly believe. So that's kind of some of the different ways of thinking about safety. The other thing that you want to make sure you do is have a conversation with the parents, both before and after you meet with the children, and just impress on them that is really harmful for them to pressure the children to say one or the other thing to you. And I give the parents a script of what they should tell their children about why they're coming in to see me, and that helps with them feeling safe and more comfortable now because they're getting the explanation from me and not the parent. A parent might give an explanation like, if you don't say what I need you to say, then I'm going to lose you and I'm going to have to pay child support and I'm going to lose my place and blah, blah, blah. So you want to make sure that the script is very clear and that you do a lot of work with the parents to ensure that they stick to that strict script to the letter. Sorry, strict script is really hard to say together. So you gotta think about safety on a level of multiple dimensions. It's not just physical safety. It's not just emotional safety. It's also consent and making sure the physical environment's appropriate for what you're doing. If you're doing this online, there's a whole other slew of issues. You don't know if the parent's listening. You don't know what kind of environment the child's in. So I tend to not like to do this virtually. I have done it on a few occasions, but the vast majority of times I like to do this in person because I feel like you can get the child to feel more safe, and you have more control over the physical environment than if they're at their parents' home and you're listening to them, in their bedroom or their parents' bedroom or something like that.
That's very helpful, Jonathan. I'm glad that, you and mediators are there to kind of provide this script and this direction to the parents to make the kids more comfortable. I think parents sometimes when they're going through separation and divorce, they can really use like the help from a third person to, some assistance on how, like, what's the best way to approach speaking to the children. And I think it's great that they have this assistance on how to best approach these conversations with the children and how to prepare them for these sessions too. And all we've been talking about like role of mediators, and this is yet another role that we kind of talked about. I think another important role that mediators play is neutrality. And Jodeen, if you can speak a bit more on this one specific role that mediators play, and how they provide this much needed neutrality to the process, and how that assists parties who are going through separation and trying to figure out best parenting plans for their children.
For sure. Thanks, Shanza. Yeah. So in the mediation process, neutrality is extremely important. As the mediator, it's their primary role to facilitate conversation, discussions, and ensure that the process is fair and respectful. So the mediator will want to avoid taking on the role of an advocate for any party in the matter, because then that will just affect the integrity of the process itself and really negate what you're trying to achieve. So it's important that the mediator stays neutral to help the parties navigate the discussion, and that if the mediator ever feels that they are unable to maintain that neutral, unbiased position, it's important to reassess their role and maybe take a different approach in that role. As I said earlier, you want to avoid dual or multiple roles, because that affects the integrity of the process. And so try to not blur those lines between being a mediator and a therapist. Those are two very different roles that that you can occupy, and you don't want them to merge into one. Of course, the skills that you have in other roles can be helpful in the mediation process, but you always have to remember that you're not advocating, you're not giving advice, you are simply meeting a goal, which is to help these individuals and these children navigate this process and encourage discussion and facilitate an important safe space for all the participants involved. I think that makes sense, Jonathan.
Yeah, no, it really does, Jodeen. And I think like staying in your lane as a professional is really important, right? Like I'm a social worker. I'm not going to give my clients legal advice. That would be A, illegal, B, unethical, and C, really unhelpful, because I'm not a lawyer. And just like I wouldn't expect a lawyer to get involved in providing psychotherapy to their clients, because that's not their role. That's not, what they've been asked to provide. So yeah, it is tricky when you're a professional like me, where I'm a psychotherapist. I work with kids as a therapist a lot of the time. I do reconciliation therapy when there's parent-child contact problems. And then I also do the family mediation, the collaborative family law. So I do have to, my head does spin sometimes a bit, figuring out all these roles. But if I'm doing child inclusive mediation, I'm not a psychotherapist, and I have to stay in my lane. I used back in the olden days, when I was young and foolish, I used to do outdoor and adventure therapy. So we'd take kids on canoe trips and do therapy. And a concept really stayed with me from there called area of permission. You want to stay in your area of permission. The parents and the children have given you permission to play this particular role with them and their kids. And if you stray outside of that role, you're going to get yourself into trouble. So stay in your lane. And if you think that you can't be a neutral and include the children's voice, then I would recommend you get someone else to do it. Could be a child therapist, could be another colleague of yours who's a mediator, or maybe a lawyer who has experience, representing children. There's lots of ways of bringing out the voice if you feel like your neutrality might be actually become biased, or if there's a perception that the parents are going to feel like you are biased, even if you're not being biased,
Jonathan, I think
so yeah,
that
always.
I was
Yeah,
sorry,
go ahead.
I didn't mean to cut you off there. Sorry. I was just gonna say that I feel that it is so against human nature to be impartial, and that human
Yeah.
nature derives for people to have a stance on something. So I commend, you and the skills that you've worked on and build it upon through mediation and through your various roles, because that's why us as lawyers, we recommend certain family professionals to do these jobs, is because we understand how difficult it is for people to be impartial. So finding someone with the skills and the characteristics and the qualities able to fulfill that role is so crucial. And I know that us as lawyers, we commend it. And the parties at the end of the process, I know sometimes it ends up feeling that you're not what's the word, that you're not thanked for the job that you've done, but really in and of itself, being able to be impartial and to be able to help guide these parties and the families together towards resolving their issues is a feat on its own.
And one of the, jumping off from that point, Joe, is and the points that you made, Jodeen, is one of the ways you can stay neutral is by very thoroughly explaining the process and the purpose of the process to the parents so that they understand it and they're not going into it with either unrealistic expectations or wrong expectations, and to help them, prepare them for getting information that they may not like. I had a file a few years ago where I did include the children. I think they were 13 and 15 at the time, so very appropriate ages to include them. One of the parents had some major personal life issue and had to go away and get treatment for it for a few months, and came back and expected to resume their role as a parent as if nothing happened. And in that whole process, the parents separated as well. I had to prepare that parent to say, well, you might not like what the children say, and you have to prepare yourself that, because one thing that parents sometimes do is, because maybe they've heard something from their child that validates their position in court or in the collaborative process or in the mediation process, and they feel very empowered that they know exactly what the children are going to say. And when the children say something different, they're really like floored by it and think, well, it must be mediator bias, or it must be parental influence on the other side. So preparing the parents to say, hey, listen, I know you might have some expectations about what you're going to hear, but you have to prepare yourself for hearing stuff that you don't want to hear, or that you're not happy about, or that contradicts what your thoughts and positions are. So prepare yourself and brace yourself, because it might be a difficult process, and that having that conversation with clients can really help them feel more confident in the process because they understand it better, and B, can help make the child inclusive piece even more helpful, because then it's going to have a better impact on the parent's position in the negotiation.
Yeah. Sorry, I also wanted to say, Jonathan, that's a really great point in terms of expectation, because it also helps just move the process along, so you don't get stuck at any roadblocks, where people then it turns into conflict, because then if you come in with expectations and they're not being met, as you say, you're gonna feel like, oh, this side is against me. They've set the children up against me, or whatever, some ominous force that's coming in and ruining everything. Whereas it's really just like, no, the reality is X and you expected Y. So
And knowing how to support the parents as well when they're hearing information that they didn't want to hear is important too. And in that case, we did end up getting a full resolution to, the separation, the parenting schedule, all that kind of stuff. But it was really tough on that parent who'd gone away. To hear that the kids didn't want to spend as much time with them with them as they expected them to. So what happened in that case was that I told the parents about, I had an individual session with each parent to explain what the children had said, and the parent who'd gone away needed some time to process that. So they got back to me in a couple of weeks, and we continued working on the parenting agreement. But yeah, it was a tough pill for that parent as well.
We are still not done with all the roles and obligations that mediators has, Jonathan. And you kind of hit on this already, which is confidentiality and trust that the children put in the mediator by sharing their feelings and thoughts with them. And we have some questions coming in on this too. How do mediators bring up the children's concerns without violating the children's privacy or compromising their trust in you? And if you can speak more on, the need to balance informing the parents about the children's concerns versus the preference to not breach the trust that a child is putting in you by sharing vulnerable feelings and thoughts. How do you do that, Jonathan? And how do mediators do that?
Yeah, so one thing I would suggest is make sure you do a lot of work at the front end to prepare parents to understand, what the process is, manage their expectations, and really clearly understand your role, because misunderstandings are going to make it really difficult to make that information you get from the children useful in the process, right? So one thing I would say to the parents beforehand is that if the children say something to me that they don't want me to pass on to you, I'm obligated to protect their confidentiality and not share that information with you. Obviously, depending on your professional designation, as a social worker, as a family mediator, if the child comes to me and talks to me about child abuse or neglect, I have to report that to the authorities, regardless of whether the children don't want me to report that or not. And again, that has to be explained to the parents, and that also has to be explained to the children, right? You want their full consent, and the key word there is informed consent. If they don't know the consequences, if they don't know that telling you about abuse is going to lead to a call to the Children's Aid Society, then you shouldn't be working with them. So a lot of work up front has to be done. You want to make sure that you have a very thorough retainer agreement that explains all this, like a consent form, the one that's worded in more legalese language that the parents can understand, and one worded in more child-friendly language that the children can understand. And then explaining to the kids that they have a choice about what information you share and what you don't share. And if they don't want you to share something, that you won't, unless it falls into those, child abuse or neglect categories where you are forced by law to report those. And lawyers may have a different obligation depending on the role that they're playing with their clients. If it's a children's lawyer, I actually don't know the answer to that. Do children's lawyers have the same obligation to report child abuse or neglect, or do they have kind of client confidentiality as the best, or as the top consideration?
That's actually a great question, and unfortunately, since I don't practice, especially sorry, children's law in the sense I've never
Yeah,
represented children, I would not
yeah,
have the answer to that. But I think that's something that we could definitely circle back to
yeah,
in the future videos, or at least provide information to our clients. That's actually very interesting, whether or not because I know that a lawyer, unless someone's life's in danger, like there's certain ways in which client confidentiality no longer becomes confidential, and there's three instances for that, one of which being if someone's life's at risk or
Mhm.
any of that nature. But that's there's very few instances in the legal field as lawyers that we are able to negate confidentiality.
Yeah.
Yeah, 100%. And kind of building off, Jonathan, where you were talking about confidentiality and trust, what do you think is an appropriate way to incorporate these preferences and all these conversations that you have with children and parents into the mediation process and in the agreements? Um, is there any way that you approach this specifically on, how to best incorporate all this feedback that you're receiving into an agreement, and how do you approach that?
Good question, Shanza. I think, you want to ask yourself, how useful is the information you're getting from the children? And sometimes, honestly, it's not useful at all. I've had kids say, I don't care. I want the adults to decide. Don't ask me. And that's what you bring back. So, incorporating that into an agreement might be tricky because you're just basing it on what the parents agree to. So, that doesn't happen very often, but it has happened on occasion. But I think it's important to ask yourself, yeah, how valuable is the opinion? Like, is it you know, are there signs of parental influence? If there are, then that opinion becomes less important. Um, but for teenagers in particular, you really want to make sure that their views and preferences are included in the parenting schedule. You don't want to come up with a parenting schedule that they're not going to follow. And we say often in this field, teenagers vote with their feet, right? If they want to be with dad, they're going to be with dad. If they want to be with mom, they're going to be with mom. If they want to be with both, they're going to go back and forth. But you can't force a 16-year-old to go with a parent they don't want to be with. So you have to incorporate their views and preferences into your agreements, and really it's up to the parents to decide how that happens, because this is a mediation process and the parents get to decide what goes in the agreements, not the professionals, unlike if you were in court or an arbitration where the judge or an arbitrator might decide for you.
Thank you, Jonathan. And before we end for the night, another topic we kind of wanted to hit on, and Joe, I'm hoping you can take like a minute or two to speak on this. That is, what about post-mediation support? What kind of ongoing support should be there for children and parents after mediation? And what are some things to consider to ensure children's needs continue to be met?
Yeah, for sure. So with regards to post-mediation support, while mediation helps families, reach agreements, the process doesn't necessarily end once the agreement is signed. And, as such, ongoing support is necessary to ensure that the terms of the agreement are being followed and to help both the parents as well as the children adapt to the new routines or living arrangements that arise from the agreement. Also, new issues can arise that maybe were not necessarily contemplated during the mediation process, or maybe the child is now at a new stage of life that requires the parenting portion of the agreement to be tweaked to reflect this new stage. These stages can be related to school, extracurricular activities, or even health issues. And regarding of the depending on the variable, doesn't matter the factor, parents will still need to be able to adapt to the changing circumstances. Children's needs, as we know, change over time, and what works immediately after mediation might not be ideal a year or two later. So in every agreement, there should be a dispute resolution clause included so that if new issues do arise, they can be looked after appropriately. Now, sort of going more to the counseling and resources side of things, post-mediation counseling for children as well as parents can be invaluable, and these services can help navigate. Sorry, I should say they should help families navigate the emotional as well as the practical changes after mediation. And for children, it's especially important to have a safe space to process these changes, as they may struggle to adjust without ongoing support, or they may feel that they cannot go to their parents with these struggles, and thus they need that outlet to be able to support themselves. With respect to monitoring agreement compliance, that's also something that comes up a lot. And being able to ensure that both parents, adhere to the terms of the mediated agreement is really crucial for long-term success. And without any form of monitoring, issues such as missed parenting time or even unpaid child support can resurface, and thus creating new conflicts. So this helps prevent one parent from feeling like the burden of compliance falls disproportionately on them. And it's important that mechanisms are in place to ensure that the terms of the agreement are being adhered to. As always, even after mediation, having access to legal professionals ensures that any adjustments or compliance issues remain within the bounds of, Ontario law. And if there are significant changes to the family dynamic, parents may need legal guidance to revisit or amend the agreement that was created through mediation. This then ensures that it remains enforceable and fair and has been adapted to reflect the current needs of the parties and children if involved. So the big pictures there is that the need for the follow-up allows parents to monitor any changes with respects to the child's developmental stage and be able to make changes and to be adapt accordingly. Making sure that counseling and resources are available to the children as well as yourselves, because separation, divorce is difficult on children, but that doesn't necessarily mean, and we've seen it, it's still very difficult on the parties going through that process. So being able to have these services available for both you and your children are extremely invaluable, and you should never feel weaker or less than because you want to take advantage of these services. Again, also honing in on the monitoring the agreement compliance as well as legal guidance moving forward. Anytime that issues arise as a result of compliance, or maybe changes do need to be made to the agreement, because as I said before, what's been agreed to through mediation immediately might not be reflective of the current familiar stages that are there 2 years from now. So it's really important to be able to adapt and to work accordingly.
Flexibility
100%.
is the key.
Flexibility is the key. Well, thank you for speaking on this, Joe. It's 6:01 p.m. Thank you, everyone, for a great session. This was very insightful, and thank you, Jonathan, and thank you, Jodeen, for joining me and Joe today. I promised earlier that our audience can snag a free meeting of up to 20 minutes with one of our lawyers, and the code to get your free meeting is Jodeen 2024. You can email Nicole in our intake department. I've shared both the code and the email in the chat. It's nicole@russellalexander.com. Thank you to our audience for joining us today. And thank you once again, Jonathan, Jodeen, and Joe, for a great session. And I hope to see you all very soon again.
Thanks for having
Thanks,
me, folks. It was
everyone.
really fun and I appreciate it.
Yeah, it was. Thank you, everyone, and have a good rest of the evening. And to everyone at home, thank you for tuning in.
Same here. Thanks, everyone.